Good afternoon. I think we'll get started because we're on a tight schedule. We've got a lot of speakers, and so I think we'll just start. My name is Grace Hum, and I teach at the University of San Francisco. I teach legal writing, contract drafting, and legislation. Well, now contract drafting. Just to sort of set up some ground rules, there are, as you can see, 4 other speakers. And I think what we're going to do is we'll all introduce ourselves, and we'll give our sort of formal presentation and leave about 20 minutes for question and answer at the end. That way we can know that we're going to get through everybody's presentation. So, first thing I'd like to do is thank Team Stark and Emory and all of the people in the steering committee, especially James Scott, who helped to organize our panel so that we can find each other and figure out what it is that we're doing together. So the title of my presentation is Unfounded Fears. And really this is directed at somebody like me who came to this conference 2 years ago. I had been teaching legal writing for 6 or 7 years by then and had never taught contract drafting. And I proposed the class to my school, and I'd thought about teaching it, but didn't really know what to do, how to get started, and I came to this conference as a way of figuring things out. So for all of you legal writing teachers, I think that there are some who are already teaching contract drafting, but if you haven't ever taught this before, hopefully what I talk about today will allay some of the fears that you might have. As I thought about whether I could teach contract drafting, I held on to sort of 2 ideas. The first, and I continue to hold on to them. The first is that law professors teach things that they don't know about all of the time. Right? Do you know, I mean, you're torts professors. Did they practice personal injury law before they became torts professors? So I thought, look, if they can do it, I can do it. It's just a matter of figuring out how to do it. Right? And the second thing was really a mantra that I came up with to ease my fears, ease other people's fears that asked me about teaching contract drafting, since I had not also been a transactional lawyer. And that was that good writing is good writing, right? No matter what context you're writing, whether it's fiction, nonfiction, legal writing in terms of expository writing, or contract drafting. You know when it's good writing, when it's clear, when it's concise, unambiguous, right? Those are paramount principles no matter what type of writing that you do. And I held on to that as the skill that I felt like I could teach, no matter what the context of the writing. Okay, so you might first think, as I thought, I don't know anything about contract drafting. And the reason is because, at least for me, I was not a transactional lawyer. I was not much of a lawyer before I started teaching. So really I had to sort of dig deep and think about how it was that I was going to teach something that I had no experience doing. And as we all know, right, we always know more than our students. And sometimes it's 100% of knowledge more than our students because they don't know anything. I felt like, look, I can at least know 5% more than my students. And if I own that 5%, if I'm confident about that 5%, if I can show them that I'm confident in my teaching of this area or these new skills, if I can show them that I'm comfortable doing it, then they'll have some confidence in me. And I really felt like the first 4 or 5 weeks, if I can demonstrate that, then the rest I'd be home free. And I did, which is part of the reason why I'm here now. I felt like it was pretty successful. So some of you may feel like I hated contracts when I was in law school, or I wasn't good at it, right? I didn't understand it. But you all know that teaching contract drafting is not about teaching contracts necessarily, right? There are obviously some important concepts, some important contract concepts that we bring over to contract drafting. But once we relearn those, and we know them, they're just sort of buried deep in our brain. Once we relearn those, we're good to go in terms of teaching contract drafting, right? So the next one is, I've never written a contract before. So maybe if you've never been a transactional lawyer, you've never actually written that contract. The reality is that as a legal writing teacher, you've written so many other things, maybe not a full contract, but so many other things that might be parts of contracts, right? If you've written clear and concise emails, memos, legal writing hypos, then you're doing pieces of contracts, maybe just not the whole thing, right? So you are defining things, definitions. You are obligating people to do things, covenants and rights. You're writing statements of fact, right? Representations and warranties. You're thinking about what the consequences of people's actions are, endgame provisions. So you're writing different pieces of that contract, just not the whole thing, and it's putting it together as the sort of learning part about teaching. Right? How do I teach contract drafting? So as you guys know, as legal writing teachers, we teach skills. So we teach by doing. We don't teach necessarily by lecturing. We might do a little bit of lecturing, but for the most part, we're encouraging our students to practice the skills that we are trying to convey to them. So all of the things that work in your legal writing class, they work in contract drafting class too. Things like peer review, pair shares, group work, right? Individual review. All of those things that we come up with in our legal writing classes can work in a contract drafting class as well. And I'll tell you that with a fairly heavy load of legal writing classes, I taught 2 sections of 20. So 40 students in legal writing and a whole other section of contract drafting. I felt pretty overloaded with the amount of paper I was going to get and how I was going to get through it all. And I found that, at least with contract drafting, the way I put it all together, I did a lot of peer review. I did a lot of group review. I did it so that we would look at the contract together or pieces of contracts together in classes so that I wasn't overloaded with a lot more to read, though of course I did individual review as well of their work. I don't know how to grade a contract, right? That worried me a lot because I didn't know what I was looking for. And the reality is that we, as legal writing teachers, grade documents that have subjective and objective components all of the time. There are things that we want in those legal writing documents, those memos, those P's and A's, but that we know our students can use a lot of different paths to getting to that answer that we want them to get to. Same thing with grading contracts, which is that we know if we can isolate what we're teaching them and the thing that we want them to learn, we can isolate that in the contract and look at that and figure out, is that the thing that expresses what we're trying to teach them, what they should be explicitly or expressly providing in this contract given the terms of the deal. Right? So if we can look at little pieces of it, although we'll grade the whole contract, but if we can think about the pieces, reps and warranties, we can think about the covenants, if they are expressing the thing that we are teaching them to express, we can absolutely grade a contract. Okay. So what do you say when a student asks, what did you do in the situation when you were practicing transactional law? For many of you, this isn't a problem. You actually practice transactional law. You did actually draft contracts. For me, it was a problem, and I really struggled with what to say, how to deal with that question. Fortunately, it never came up, but I did have an answer. I don't know why nobody asked me that kind of question, but I said, well, I would have said, well, I've looked at a lot of contracts, and this issue never came up, and that's true. Or it might have been true at least. I have looked at a lot of contracts. Maybe I didn't draft them, but I've looked at a lot of contracts, mostly just because I'm a human being, not because I'm a lawyer. Another question that I sort of really had great fears about what I would say, what kind of contract law did you practice? Right? And again, since I wasn't a transactional lawyer, I didn't have an answer to that. And my true but yet again ambiguous answer was, well, when I worked for the Department of Labor, there were lots of employment issues, and when I worked for the Ninth Circuit, there were lots of contract issues that I looked at. So it was a way of me trying to figure out what to say to these questions that I thought would come up given my students knowing that this was a contract drafting course being taught at this school for the first time. Okay, I have no idea where to start. What do I do? I think that the first thing you do, right, is that you go to conferences like these and you get information and you talk to people and you find a little bit of confidence because you're around other like-minded people doing the same thing. The next thing you might do is you might go to the Emory Law School's Center for Transactional Law and Practice. They have a ton of resources, and it turns out that the organizers of this conference were smart enough to put that in hard copy in these bags that you've gotten. So there are all of these resources that tell you, for example, in particular, all of the contract drafting textbooks that are out there. That's a great list to start with. I ordered all of those textbooks and put them in front of me and took a look at all of them and tried to figure out which of these make sense to me. Which of these teaching manuals do I like? What do I do? And once I figured out which textbook I liked, I contacted the author and said, I'm teaching contract drafting for the first time. Can you help me out a little bit? And as you all know, coming to a place like this, it's really great to see how much everybody will mentor you, how much advice they're willing to give to you, and how much they're willing to share syllabi and exercises. So go find people to talk to about syllabi and exercises, and to gain a little bit of confidence. And then another way to do this is to go to the different listservs, right? So for the Legal Writing Institute, if you're a legal writing teacher, there's the contract drafting listserv and the deals listserv, and I think Emory maintains both of the two bottom ones. So there are, there's ways to get there, right? And as a legal writing teacher, thinking about teaching contract drafting, and when I started to get into the materials, all I could think of to myself was, look, I was writing in a narrative form. I wrote paragraphs and had thesis sentences. And I'm not doing that anymore, but I can write in numbered sentences. I think I can. And I did. And it was, I think, a great experience for me because I learned something new. And I was fortunate that it was a great experience, and so now, rather than just teaching one contract drafting section at my school, I'm going to teach 2 contract drafting sections this coming semester. And I think that my school and my students are all the better because as a legal writing teacher, I said, this isn't here, we need to do something about it, and I was willing to do that. So I think so many of you are already teaching contract drafting at your schools, so you might not have really needed this, but for those 1 or 2 out there who are still thinking about doing it, I hope this allays some of your fears.
I'm a Mac person now, so I hope that I can make this work. We actually know what we're doing. I remember us. Yep.
Well, my name is Miki Felsenburg, and this is Barbara Lentz, and we are here from Wake Forest University School of Law. We're glad to be here today. A little bit about us. Neither one of us, like Grace, actually practiced transactional law. Barbara was a litigator, and I was a litigator at a long time ago. I'm about to start my 17th year of teaching legal writing. I had an MBA. I have an MBA, but that I found out didn't help me a whole lot when it came to this, although I did understand a little bit maybe more about business than most of my students. Grace was right about that. And what Barbara and I are here to talk to you about, Grace has talked a lot, eloquently, to hard act to follow, on the similarities between teaching legal writing and teaching contract drafting. I've just finished teaching contract drafting for the first time. Barbara, thank God, has taught it 10 times, so she dragged me kicking and screaming through this first time. I couldn't have made it without her. But we're gonna talk more about the differences between teaching legal writing and contract drafting, some of which are, actually pretty helpful, and some of which are a little bit scary. We're going to talk a little bit about developing problems. There are in your materials, not up here, a couple of the 2 exercises I gave my students this past semester for a grade. They also did a paper at the end for their big grade, but there are 2 contract drafting graded exercises, and I'll have good news and bad news about those when I get to them. And we'll talk about developing business sense and skills and how to evaluate them, how to assemble a portfolio, and a few other things that are different for teaching legal writing.
So the handouts, I also put together a list of the top 10, I'm Barbara Lentz, and I did a little bit of transactional work. Ted Becker and I were at the same firm very briefly. We were summer associates together a couple of years ago, and there were 150 lawyers between my firm's downtown and suburban office, and Ted was at the state capitol. Out of 153 people did litigation and transactional work, and I was one of those 3, but I wasn't there very long. So I don't have a wealth of transactional experience. You can absolutely do a great job in the course with that. Okay, so I start with outcomes because I think, what do I want my students to get out of this course? So here's some learning outcomes for drafting. And I'm trying to think more intentionally about the new draft standards that are coming out for outcomes and assessing the student learning outcomes. I'm a big believer in the outcomes and formative feedback, and so a similarity of drafting and legal writing is we already do formative feedback. We think we should be teachers. So we'll start from that position. But anyway, very quickly, our outcomes, and then we'll spend a little more time on each of these. There's substantive law that they have to learn. Competency in writing, that's writing, revising, editing, peer editing, annotating work. Those are skills they have to have. One of the things that the draft standard says is students need to be able to practice law when they graduate. They need to be able to do these things. Okay, they develop business sense, and develop might be charitable, because they might not have any business sense. Some of my students come to school and they don't watch the news, they don't read a newspaper. They don't even read it online, but they do sometimes watch Jon Stewart. So they have the Daily Show, and that's about it. So how do you help them develop a business sense? Professional skills are crucial, and not just values and ethics. One of the first years I taught, a student said, I don't need to know ethics, I'm a transactional attorney. That is so funny. Ethics are not just for litigators. Okay, yeah, students. And finally, assembling a learning portfolio. We'll spend, I think, the bulk of our time there because I want my students out of their drafting class to know how to do things, but they'll also have samples that they can use, not just of their own work, but things that they can take to practice. Imagine that, things from law school that are practical to the practice of law. I mean, samples you can use when you actually get the problem, or at least know a process. Okay, so that's where we want to start. The first of these 5 or so tips, a basic understanding of substantive law. There is substantive law. There's content and there's skills that they need to learn. But what is a representation? When to use a rep instead of a covenant or a conditional precedent? How do you draft those things? The consistent use of shall. I mean, there's actual substance that they need to know about drafting that works for any kind of drafting. And then there's substance for the type of transactions that you want to do. And you might decide to specialize in one particular area. If you like real estate, then specialize in real estate. If you like Hollywood movies, then specialize in entertainment stuff. Because it helps to have a better understanding of the area of law, the substance that's there. I'm lucky that I teach this course, contract drafting, 2 different ways, and one is for second years and one is for third years. And the third years, when I get them in their second semester, they know they have to go and work, and they are eager to do things and to have real knowledge. And they've taken other courses, unlike your first years. They've taken other courses, which is great. Okay, so
remember also that when they come into the class, they've probably forgotten their contracts. If you're teaching a second year or a third year course, their first year contracts is in the rear view mirror. And one of the things you absolutely have to do at the beginning of a business drafting class is review. Barbara told me you have to review parallel evidence, you have to review basic contract concepts, because they just are not going to remember it if you're teaching this in an upper level course.
Well, they need to know more about parole evidence than do we use the Four Corners test? They need to know what is parole evidence and how do you guard against that. So you have transaction documents. How do you avoid the litigation? Let's see. Competency in writing is drafting, revising, and editing. I think a cardinal rule for drafting that makes you a better legal writing teacher is to make precise documents. Because my students are second and third years, I'm more exacting in the level of precision that they have to get it right. The goal is to have a document that maybe I could change 1 or 2 things for nothing, but we could just send to the client. That's the goal. They're not there yet, especially not if you get it. Okay, but we start with drafting, revising, and editing.
And of course, in teaching contract drafting, you're working with an entirely different kind of document than you're working with in teaching legal writing. A couple of very significant differences. Students in contract drafting have to learn how to work from a form, which they are likely not getting in legal writing, although in legal writing they're constantly asking you for examples. The examples aren't too very useful to them, but when you're teaching contract drafting, they have to be able to work from an existing form. And that's a different skill than starting from scratch. Of course, they obviously also have to be able to start from scratch. Significantly also, the audience is different than what you're teaching in teaching legal writing. Your legal writing, traditional legal writing readers are the judges, the clerks, the senior partners in the law firm that you might be writing an objective memo for. Your readers of your contracts are much more peers than the people. I mean, they have certain expectations. Your clients are your business customers, and they've done this before. They know what they want in this contract. There's an entirely different expectation in that audience than there is in writing for a different audience. There are also third parties involved. If one of the examples that I'm going to tell you about was I had my students write a contract where they hired Mark McGuire as a junior high school baseball teacher. And one of the things they didn't think about as they were doing that is, well, the kids and the parents have an interest here too, not just the school doing the hiring and Mark McGuire being the hiree. So they were also affected by the fact that of this third-party document, which is a very different thing than what you're doing in legal writing.
Something else, a big difference that comes in either competency in writing or substantive skills, there's a drafting process that works for any kind of deal or any kind of document you work on. Sometimes your process is 3 hours, and sometimes it's 1.5 years. If Microsoft is buying a business unit that's in the European Union and needs European Union approval or antitrust provisions in different countries, that takes a while. You've got 18 months. And it's a lot of money, so you could have many, many hours spent on a document. I start my drafting class with the students doing an exercise from Tina's book, where without any instruction, they draft a contract for the sale of a car. And so the car's worth about $15,000, and they tell me they work in teams. They tell me how many hours they spend on it. And so we figured that the bill's about $10,000 to sell a $16,000 car. That's a really good thing for them to get. And if you know where you are in the drafting process and how long the deal should take, then you have a better way to gauge the level of sophistication and detail, and do we have some rough justice here and get it done. But you can't just eat up. I mean, that's a real world skill. You can't eat up all of the value of the transaction with the lawyer's time. Okay, so familiar with the drafting process. And also there's typical provisions in every contract. Your students should know that by the end of the course. They should know what's typically in every part of a contract from start to finish. They should know the typical kinds of boilerplate, and they should have enough fluency, familiarity to pick and choose which ones go in each provision. So that's a pretty simple, even for simple contracts, that's a good goal to have by the end of the semester. Maybe two more points on audience. I have an audience exercise that's available online. It's a snack cake. Give me a definition of a snack cake. Look at a vending machine and tell me what snack cake means. And it's to be used by a school district with a requirements contract with a vending company. Under state law, you can't sell snack cakes anymore, so we need an exclusion. It's pretty hard to have that definition. So they have to draft it. And we think about, what if the person getting it is a nutritionist sitting at the desk? How do you write it? What if it's the guy in the back of the vending machine truck? How do you write it? What if it's your general counsel who hasn't practiced law, but is a trained reader and trained writer? How do you write it? They have to come up with a definition that works for all those people. But then they send 3 different letters, one to each member explaining the definition and how to use it. It's a great exercise, and it's a snap to grade. But it's a really valuable exercise for the students and audience. Last point on audience, Unlike litigation, the next time that someone sees the drafted document is likely to be when someone's breached and they're trying to get out of it. And so you have a very hostile reader. How do I get out of this? There's ambiguity, there's something here. So they need to think about writing a document that will survive hostile review.
Yeah, which is really different, again, from what you're doing when you're teaching traditional legal writing. The reader and the user of your contract is, first of all, sophisticated, knows what he or she wants, and maybe will be reading this with an eye to how do I get out of it. It needs to be able to withstand the hostile review. One of the first things that really struck me in teaching business drafting is if I'm a litigator working with a client, that client looks to me as the expert. I have, I fell down, can I sue someone? Can I get any money for this? What's it worth? My business drafting client is expecting me to add an entirely different kind of value and isn't looking to me as the expert, more as a consultant. I need to get this deal done. How can you help me get on paper what I need to do? And what I need to do, I already know. I need to buy 150,000 widgets, or I need to do whatever. It's not a question of can I sue someone? What is your expert opinion? They might ask us for some expert opinions in some areas. Do I need a force majeure clause? What does that look like? Although they probably know better than you when you come in the door. For my students, this was a real eye-opener that when they came in the room to write a contract as a business lawyer, as a business drafting lawyer, as a deal lawyer, they weren't going to be the look-to expert who had all the answers. They were the consultant, the peer, and the relationship was going to be entirely different than the ordinary litigation.
So as a deal lawyer, your client's the expert on the business, and you have to learn when you're in practice, and I think you can start learning about the research that is entailed in learning about your client's business. I have my students follow a company that they pick, and they write a paper at the end of the semester. Each student writes it on their own. So they've set up an RSS feed. They know how to look at Edgar and find publicly filed documents. They can pick any company that's traded on a U.S. exchange. They have to know the SIC code for the company, what's going on in that industry, what are the regulatory hurdles coming up. If you're in banking and you make a lot of money off debit cards, is your client concerned? What could be happening? So they have to read the paper and do all those things. And I have alums, my former students now, coming in and telling them, you can't bill for that. You have to do it, but you can't bill it. But here's how you can find those things. So that's a really useful skill. And anytime your student, from teaching legal research and writing, anytime your students can refine their research skills, they're so much better off. And they don't necessarily know it until they go out and try and work. But they're so much better off with that. So they have to know the client's business. And adding value is a little bit different, I think. But your clients, because it's a consultant role, have to think about making sure they earn their fees, because that's the nature of the real world now for legal services. So if you have a fractional ownership, there's a private plane. We can't afford our own, but we'll share it. What should the brokerage fee be? There's examples that they can have so that they develop some of that. And we look at term sheets and provisions, and if they learn enough about a certain area of the law, private equity placement, we'll pick an American or a European clawback. Which one do you want? Why? How do you prepare your client? What's the strategy for one or the other? So we try to do all those things so they can add value to a deal. Let's see, professional skills. Unlike legal research and writing, your students probably took PR. Or if they're third years, they might have taken professional responsibility by the time that they come to your class. They're ready to hear about professional values and ethics every day. It's really a good use of class time to talk about ethics and being an ethical practitioner in every class period that you have in contract drafting. In legal writing, I think we do confidentiality and
Plagiarism.
plagiarism, duty of loyalty, but it's pretty small. We have so many other things we need to do.
My students were shocked in the business drafting class and how often ethical issues came up in class in discussion. It was a real different experience for me than teaching legal writing. They really wanted to talk about ethical issues in business. When they started at Barbara's urging, I had them studying the company all semester, and they would ask questions about, well, my company did X. Do you think that was right? Or what do you think, as a lawyer, I should have done? So I found in almost every class, while we were trying to figure out how to write a covenant, we were also talking about what was an ethical way in which to answer a business problem. It came up almost every day. A real eye-opener for me was that my students did not understand collaboration. You always assign, I know you assign them to work collaboratively. Well, this is what happened to me on my first assignment, the Mark McGuire contract. They wrote the contract in groups representing the school system. They were all in the same small, they were small groups, and they each wrote a contract. And then I had them exchange them. And in addition to my feedback, I had them get feedback from another group on that group's version of the contract. Well, this is what happened. This is what they thought was collaboration in doing that review. They sent it to each other. Each one of them put Microsoft Word comments on it, and then the last one sent it to me and back to the group. And that's what they thought collaborative peer feedback was. And the way I understood that they did that is the last guy to comment on one other person's group wrote some snide comments. And I ragged on the class and I said, you never are sarcastic when you mark up someone else's work. It's unprofessional. You don't do it. And to his credit, he came to me and he said, the other members of my group didn't see that. I was the last one who wrote comments and I just sent them to you. So I had to sit down and teach them. We spent a part of a class time talking about, okay, when you collaboratively review someone else's work, that means you get together and you talk about it and you look at it together, and as a group, you decide what to comment on. Sure, each of you get to throw your ideas in there, but then nothing gets put on there that you don't all agree with, or that you don't all think adds something to the review. So they really thought they were being collaborative in their review by passing it along through email and each of them individually commenting and never changing anyone else's comment. So it was a huge, wonderful opportunity to teach them, okay, maybe there's an appropriate time for that type of commenting. But when you're supposed to do a group review of another group's work, that isn't it. Then you do that as a group, because that's an entirely different learning experience, right? You're learning from 3 or 4 more other people in addition to just yourself.
So I think you give, I try and give really deliberate instruction. And maybe I do too well the first year, scaring my students about not working with other people, no collaboration. And also because when they come to me in contract drafting, it may be the only time in law school that they work in groups. It's just another way that law school is at odds with the real world, in my opinion. What do I know?
But the real world's a little different there, because you don't usually work in groups with peers. You work in very hierarchical groups, and there may be other professionals, accountants or engineers, whatever they interact with, business people they interact with, but the legal team is very hierarchical. So there's a senior partner, maybe there's another summer intern, and then there's the junior associate a year or two out of law school.
It could depend on the deal. If you've got a 400-page M&A document, then you have to split it up. But collaboration. So you give them instructions on collaboration, and I always allow some feedback. I give my students an opportunity to rap on their teams at the end. And usually they say very good things about their teammate. But just knowing that that evaluation is coming has taken care of the freeloading and has also taken care of the whining, because you have an opportunity to evaluate your team members. don't tell me about it, wait and get the form and put it on there. So I don't have to listen to it, I love that. Self-evaluation is a skill, I mean, to reflect and figure out what you know, what you don't know, how do you find things. They have to get that in law school because we can't make them a master of anything. Maybe, you know, they can't make them, I don't think you can be a master of anything in law school. Maybe using a lot of paper, I guess. Or drinking coffee or something. But to figure out what you know and what you don't know and where to start and having a process, a deliberative process that you can use for any kind of situation, any kind of exercise that you can go through and come up with polished work, that's a great thing for them to have. And also some confidence that they can do it. And the last thing that's a big difference from the teaching legal writing is that we want our students to have a learning portfolio by the time they leave. So they have a wide variety of nature and number of assignments. Some are big, some are small. They get formative feedback on all of them. That's one reason you have them work in groups, so that you can sleep at night and see your family. But you need to think about that with problem design.
The two problems that I used this semester, the first one was the Mark McGuire hiring. I think it was too soon. This is what I did wrong. It was too soon for them to write a full employment contract. And I did that probably a month into the course, and they really weren't ready to know. Now, I told them it didn't have to be complete, it didn't have to have boilerplate, you know, just do the hiring. But it was still a bit early, and there was a huge variety in what I got back as far as quality. I also gave them a form for feedback on each other's groups. That form turned out to be limiting. When they did their second group project, in which I had the groups comment on each other's work, I didn't give them a form, and they did a much better job. They just wrote a memo to the other group on what they thought they had done well, what they thought they hadn't done so well. They also redlined each other's contracts, of course. But the feedback memo that they invented themselves, now one thing is it was later in the course, so they knew better what they were doing, but it was also not as limiting as my giving them a form. It was just some boxes to fill in, they filled them in, they were done. It didn't get as rich feedback as letting them loose on their own. Both of the assignments that I gave are in your materials that are online and on your disk. The first one was very detailed, hire Mark McGuire and all that sort of thing. The second one, I let them sort of make it up. I want you to they were divided into two groups of groups of two that worked together in a group of four. Two were sellers, two were buyers, and I wanted them to sell something that was patentable or scientific or something that would be valuable. One of them made up a bark box that enabled a dog to talk. And so they did, two were buyers and two were sellers. That assignment I just gave them verbally. I didn't give them written assignments. And how often in practice will you get just a verbal assignment from someone? Go do this. Again, I thought it was better. It worked better for them to not have a big, long list of things they had to do. They went out and they were really, really creative, and they wrote some magnificent contracts that were useful in their own portfolios when they left the school.
Maybe as writing samples. I try and design repetition in. So if I start with a executed document, the first thing the students do is reset the form, and then they'll write it for one side, and then they'll review another group's work, and then they'll write it for the other side and review the work. And so they've seen the same exercise 5 times. But for me, I only know this small piece. It's great for them because they really know it inside out. They know what to look for. If there's something from the form that's missing, they can figure out how to add it. They can do, it's a small slice, but it's great for them. And it's, drafting process, something they can do anytime. You want to think about grading rubrics. If you have a large nature and number of assignments, then maybe try and design a quick grading rubric. What skills do I want from this particular exercise? It's not like legal writing where you have an appellate brief and everything comes together. You don't necessarily have a capstone assignment in business drafting because you can't give formative feedback on it. You can do summative, but you can't do formative feedback. I can't, because I like to sleep at night and see my kids every once in a while. Every once in a while. The biggest difference that we both found from teaching drafting and legal writing, I think, is the amount of prep time. Because after 10 years, I'm sure that I could teach legal writing. In fact, I have once or twice. I could teach it from a Post-it note. There is no way I could teach a drafting class, even if I've done the same class 10 times, from a Post-it note. I mean, there's a lot more that goes into it with examples and an in-class exercise and thinking through all of the stages of first you do this and then he'll edit it and then it goes over here and then you rewrite it from that side. So it helps to have a plan. And so starting with the learning objectives is a good way to plan for that. But there's a lot of preparation that goes into it. I think it also makes you a much better legal writing teacher and better at precision. I use definitions to teach rules. Because really, a rule is nothing more than a definition. It works really well. It works really well. Anything else?
I think that's it.
Thank you.
Thank you.
Okay, I'm Carolyn Broering-Jacobs. I teach primarily first year legal writing at Cleveland Marshall, but last year, after attending this conference 2 years ago, I convinced my associate dean to let me try teaching transactional drafting. And I did it largely based on ideas that I got from this conference 2 years ago. So I think kind of going back to the fear, which is really what I want to go back to, the fear that Grace talked about, I embraced that fear. And what I want to talk to you about is the solution that I came up with for dealing with that fear and what I discovered as these wonderful byproducts of how I solved my problem. I was a litigator, big firm litigator, did a lot of litigation involving business deals gone bad. So I knew that I knew something about transactional work. I knew something about problems that crop up in transactional work, and I knew that there was a big hole in my own legal education that I wished someone would have helped me to fill, so that when I became a litigator, I would have been better equipped to help my clients. So that's what motivated me to say to my law school, hey, why don't you let me try to do this? But I wasn't confident that I could do it on my own, and I latched onto something someone said at this conference a couple of years ago, which was, well, when I bring in an adjunct, I always teach with that adjunct the first time through. And I thought, well, that's brilliant. I'll teach with an adjunct, not because I'm worried about the adjunct so much, but I'll bring someone in who knows something about the substantive areas that I'm worried that I can't convey to my students. So last summer, I team taught a transactional drafting course that we called Drafting for the Basic Business Deal. We used Tina Stark's book, which I highly recommend for folks teaching this kind of course for the first time. The book is great, and the teacher's manual is wonderful. It's written for someone who, it's written for somebody who doesn't know anything about that area of the law. But my teammate, the practitioner I taught with, loved it as well, and she knew substantively, she came at it substantively with much greater expertise than I did. So we taught Drafting for the Basic Business Deal together in a 2-week compressed course. And what we discovered was that, I originally conceived of this team-taught course as a way to add to my expertise and to add depth to the class given my limited experience in deal making. And what we discovered was that bringing these two perspectives together added something to the course and the students' experience that made us not want to do it any other way. I had sort of thought this was going to be we'll do it once this time, and then I can go off and teach it on my own, and if she wants to teach it on her own, she can. And we discovered it was really great for both of us. So today, what I'd like to do in this short time is talk a little bit about the course and what we did, how we approached the planning and the teaching. I'll talk a little bit about our impressions of how it worked and about the students' responses. And I think I'll wrap up with just a little bit about some interesting, but not really that surprising, in retrospect, phenomena that we saw in the course evaluations and the differences between what I saw in my course evaluations in a team-taught course and a course that I taught on my own. So what did we do? Our course content, I kind of lay out a little bit on the handout. I won't spend any time on that. We taught the course over 2 weeks. It was a 2-credit class, so we had to have 24 hours of teaching time. So we did 3 Saturday mornings, and so it was 3 weekends, and then the Tuesday and Thursday evenings in between. And we did it that way because we knew, even though we told our students this is going to be a lot of work, we knew they would probably work during the day. And we wanted to make it accessible to as many students as possible because, of course, again, going back to the fear, I was afraid maybe no one would want to take it. It turned out that wasn't the case. So we had 2 weeks to teach it, and we managed to get the students through 2 major agreements, a car purchase agreement and an aircraft purchase agreement. We used the exercises. There's some extensive and really excellent exercises in Tina Stark's book, and we used that for our first time through. We incorporated drafts on which the students got formative feedback on both of those agreements, and then they got summative feedback as well. They did ungraded drafting exercises for each class to go along with their reading, and we had them take a couple of quizzes. We, like I said, did it all in 2 weeks. It was a lot of prep and a lot of commenting in a short period of time. I was really tired by the time we finished, and I think our students were really tired as well. Now, as I said, we team taught it part because I was scared, and it also in part because it was a way for me to get someone into the classroom. It was a lawyer I knew, and we'd worked at the same firm. We didn't really work together because she was a business lawyer and I was a litigator. I knew she'd be a great teacher. She wasn't confident that she'd be a great teacher, and I said, well, come in, let's do this together. And so it was a way to get her into the classroom, and teaching it in 2 weeks was a way to minimize her commitment so it didn't seem so scary to her, like, I can do anything for a couple of weeks, even if I'm horrible at it. Even if I don't like it and never want to do it again, 2 weeks will work. So that's why we taught it together. Another reason that we taught originally with 2 of us is because we were doing this compressed class in this short period of time. We really needed 2 bodies to manage that much information and that much commenting and feedback in that short of time. Now, how did we do the teaching? We did the teaching in a very collaborative way, and I think we collaborated. We tried hard, and I think we were successful to collaborate on all levels. And when I say collaborate, I mean we didn't. I think there are lots of models for team teaching. There's kind of tag team where you do something and then I do something and then someone else does something and we're a team. It wasn't like that. We really were working together. One of the things I did in preparation for the class was a little bit of reading on team teaching, and one of the things that I discovered was that students responded better to team-taught courses where the collaboration was transparent and the students got it. I read a couple of articles where faculty worked really hard collaborating in the planning of the class, and it didn't translate. The students didn't get the connections that they were trying to make because they couldn't see them. They were all behind the scenes. So we tried to do a lot in front of the students so that they could see the collaboration. So we collaborated on course design, but we also collaborated on teaching, on commenting, in feedback. In course design, we started off creating a comprehensive plan for the whole course, which we changed a lot as we went along. I could show you sort of the nice tight plan that we had at the beginning, and then the kind of mess that I keep thinking I'm going to revise, so I have a nice typed plan again, but I still don't. It's just a mess with Post-it notes. Because we had to do a lot of adapting as we went on. We were very optimistic about what we could accomplish together. We also then would create a plan for each class so that we would split responsibility for in-class topics, and we'd take turns kind of leading the discussion. And for the things where one or the other of us had responsibility, then that person would also take responsibility for any exercises or in-class work that went along with that topic. So, for example, if the students did an exercise on an issue that I led the class discussion on, I'd also do the commenting on that exercise. So we split that kind of commenting up. It was ungraded feedback, and it was a way to kind of lessen the workload, which was nice for both of us. We also collaborated in teaching in class. I had a colleague who team taught an interdisciplinary class with somebody from another college, and the way they did it was he came to class and she came to class, and he never came to her classes. And it was a disaster. It didn't work out well at all. So I knew we needed to both be there, and not only were we both there, we both were in front of the classroom the whole time, and we both were engaged, so that even when one of us was speaking, the other might chime in with something. And sometimes when one of us was speaking, the other would ask a question. I'd say, hey, Susan, when you were working through a deal, what would you do when? So we were both really paying attention. We really had to pay attention and keep up, which was good for both of us. And it also allowed us to help to discover things that might be problems for the students. I could chime in and ask her a question when I realized I had a question and the students were afraid to ask or didn't realize that they needed to ask a question. So that was another way that teamwork worked really well. We also, one of the other nice things about having both of us is I stayed much closer on track to my plan when I was sort of responsible to another person. I knew I had to cede my time, so I needed to get through it. And we were somewhat flexible, but I found that I was better able to stay on track because of that. Now, one of the other things that our collaborative approach to teaching did that I think worked really well, and we discovered this by accident, it wasn't like we came into it with this in mind, and that was that we tried to model lawyerly decision-making for our students. It started off, it happened quite by accident. Before the first or the second class, I was asking my adjunct questions about something that I disagreed with in the text. I said, I know that the text says we should do it this way, and then this is the solution to this problem, but I kind of would go at it another way. What do you think? And it was, again, born of my own insecurity. Like, well, I kind of think it should be this way, but she's the real deal lawyer, so maybe she knows better than I do. And heck, Tina Stark wrote the book, and she probably knows better than I do, too. So we're talking about this, and suddenly Susan says to me, the students would benefit from hearing this conversation, because this is what we do, right? This is what lawyers do. So we started to have those conversations instead of in my office before class, in front of the students. And one of the things I'll touch on in a bit is how that created some problems for a couple of the students and some ways that I'd adjust for that in the future. But I think that it turned out to be a very happy accident, because I think our students learned a lot about what lawyers do by our ability to engage in that kind of conversation. We also, in addition to collaborating in the planning and collaborating in the teaching, we also collaborated on the feedback. In our, I already explained how we kind of split up some of the work on the ungraded exercises, but on the graded work and the commenting on the draft of the graded work, we both commented. And I'd originally thought, well, we're going to have to go through and harmonize our comments in some way and make sure that there aren't any inconsistencies. And then we thought, wait a minute, this is exactly what lawyers have to do. As a deal lawyer, you end up getting comments from lots of folks. So we talked to our students about how you're going to get comments from both of us, and you're going to have to make some decisions. And we would have conferences with them, and we would talk through the reasons, how to resolve some of those differences. But it was another way that the students got to discover how it works to be a lawyer, and it actually ended up making the grading feel easier, because I didn't feel like I was carrying that burden all by myself. And so I knew most of the time if I didn't comment on something, she would, and vice versa. So that was a nice thing for both of us, and it turned out to be really good for the students. Now, in terms of assessment, we did do more collaboration before the students got their documents back. When it was actually time to grade, we would start with a grading checklist, a rough grading checklist that we would sometimes revise as we were working through it, and we would both use that checklist. And then we would meet to go through how we assessed each of the things that we were looking at and agree on scores for different things. And then we'd use, I have a pretty decent administrative assistant, thankfully, and we used her to come up with our common score sheet. And that actually was much faster than I thought it would be. I went at that thinking this is going to take us a long time, this is going to be very hard. Turned out, we've been teaching the same class. We were looking for the same things, and most of the time we were in full agreement. A couple of other things that worked really well for the class. One of them was TWEN. I've used TWEN in lots of classes. Using TWEN in a team-taught class worked particularly well. It was the first time that I had ever had students submit assignments on TWEN. I'd used it more as a resource and a way to transmit information to the students. They turned in everything, graded and ungraded, using TWEN, so that then we both had access. And we both had everything that the students did. We also used the TWEN gradebook, which was the first time I had tried that, and it was wonderful because we both had access to the gradebook at all times, and you could both input information. So that actually worked very well, and is something that I definitely recommend if you're going to try to teach a class. Now, what worked from our perspective? We discovered a number of things. First of all, we discovered that the students really appreciated, and we heard this over and over again, how much they really appreciated hearing 2 points of view, not having just one person at the podium all the time. And we discovered that the differences in our expertise made a big and positive difference in what we were able to offer in the classroom. We came at this thinking, well, I came at this thinking that my lack of true transactional experience was a detriment. And I think that this is useful for anyone who's teaching legal writing, who's thinking, some of those fears that Grace talked about, they really can be assets because you think about different things and you think about different questions. So it's a real valuable thing in the classroom, not necessarily a detriment. We also discovered we could use those differences in our expertise to discover opportunities discover opportunities to talk about problems with the transaction, because I would see different problems than my co-teacher would see. So that was another valuable way to use two people in the classroom. Now, the students liked getting two perspectives. We also heard that they thought it made the class more interesting, especially with those long 4-hour Saturday classes. It was sort of nice, I think, to have that somebody different getting up and helping them through the material. They identified that it was nice that one teacher could identify when another teacher's explanation wasn't clear and could help with the clarifying. Some students thought that it helped them get more timely feedback. I don't know if it really did, but they perceived that as a positive thing. And the students specifically noted that they appreciated getting more feedback because they had more than one person commenting. So they liked that as well. Now, this was not without its negative feedback. We actually had one student who we had 17 students. We had one student who intensely disliked having two teachers in the classroom. And that student reported things like, the different experiences and points of view was sort of interesting, but it was often confusing because they weren't on the same page. They wanted us to sort of be walking in lockstep. They wanted those answers. And one student, our effort to model lawyerly decision-making didn't work for one of the students who wrote on the evaluation that our rather constant consulting with each other was distracting. And I think I can appreciate that. And I think one of the ways to deal with that is to be really upfront with the students early in the course, which we didn't do because we really didn't decide that we were going to do that early enough in the course the first time around. Be upfront about the teaching method and about the reasons for it. And if the students know that that's what they're going to get and they don't like it, they can find another class. And if you're upfront with them early on, I think that works out. Now, I observed some things on my course evaluation that were interesting to me. One of them was that we got our standard course evaluation asks about exploring alternative points of view. And no matter how hard I try in my first year course to offer them 17 different ways to do a particular thing, because I think I'm grading them and sometimes I tell them it doesn't work the way that they choose, I always struggle a little bit with that. And in this team taught course, our scores were off the charts. on alternative points of view because it was very obvious. There were two of us giving different points of view. So that was a nice thing for the students to see and understand and appreciate. I think, you know, no matter how much we tell them, you're going to be writing for different audiences, unless they're actually writing for different audiences, it doesn't translate. The other thing that I discovered was that while I never have a problem with my students with clarity and organization when I'm teaching my first year course, it was a little harder for the students to feel like the class was as clear and as organized with two of us. And I think that there were some things that we could do that I will do differently in the future. We would always, one of us would always introduce what we were going to do for the day. I think if we also wrapped up in a very clear way and walked the students through, okay, this is what we did and these are how the things connected, to really literally connect the dots for the students, I think that maybe some of those problems could be resolved. And I think I'm running out of time. So I'm going to just close for now, and I'll be happy to answer any questions you all have at the end.
Well, good afternoon. I'm Ted Becker from the University of Michigan, and my part of today's presentation is to fall on the sword. And I say that because my topic is rookie mistakes to avoid. Now, many of us up here on the panel are rookies, but I certainly am. I just completed my first semester of teaching transactional drafting, so I'm a rookie. And then when it comes to mistakes, oh yeah, there's a bunch of them that we can talk about. Now, I certainly was not holding myself up to any sort of unrealistic standard, I don't think, in going into this course. I didn't expect perfection. There's going to be inefficiencies, of course, anytime you teach a course for the first time. But what I really want to talk about today are those sorts of mistakes that I made looking back at things from the vantage point of an experienced professor in other fields or in other subjects, those mistakes that really eat at me because I should have known better. I've been teaching legal writing for 10 years, so when it comes to teaching, you know, I'm a rookie at transactional drafting, but I'm not a rookie when it comes to that. I'm like an experienced player who's called upon to just play a different position. So I had some idea going into this class, you know, an inkling of how much effort it would take to get the course up and running, what, you know, the problems that would arise from teaching a class for the first time. I felt some of the same fears and concerns that we've heard the other members of the panel discuss. You know, we've heard a lot from from various members of the panel about ways to make the transition from teaching legal writing to transactional drafting a little bit easier by taking the lessons that we already know from legal writing and transferring them over. That is absolutely wonderful advice. If you don't do what I did, which is basically to, for whatever reason, put all that aside and forget about it. In other words, the problem is that, you know, we have all this great advice about how to teach transactional drafting. I mean, I attended this seminar a couple of years ago. I read all kinds of materials, and then what did I do when I started teaching the class? I just put it all aside. I don't know why. That is the first rookie mistake to avoid. Listen to people who know what they're talking about. You know, so I think it's like a function of overconfidence, in a sense. Now, not overconfidence from a subject matter perspective, but from a teaching perspective. I didn't know everything about teaching transactional drafting, but I was too hasty to throw away the lessons that others tried to teach me, other experienced transactional drafting profs, but also lessons that I learned myself through 10 years of teaching. Now, the first one of these are, here's a simple example, and Barbara's already alluded to the value of this, but grading rubrics. Now, I have no excuse here because I already said I was at the conference 2 years ago here, and there was a presentation on this by Robin Boyle, David Epstein, and Sue Payne. I attended the presentation. I got the materials, and yet for whatever reason, when it came time for me to grade assignments this semester, I didn't use them. I didn't create my own grading rubrics in advance. And I think that the results of this were probably sort of inevitable. I felt that very soon, as soon as those assignments started rolling in and I was grading them, I felt like I was back in the position I had been in almost a decade ago in my first couple years of teaching legal writing. It was taking forever. I felt like I was making the same comments over and over. You magnify that by the fact that this was the first time that I had taught a graded course as opposed to a pass-fail course. The legal writing course at Michigan is graded pass-fail. So I was particularly paranoid about grading uniformly, and that in turn inspired me to keep going back and re-back over all the papers to ensure that I was grading consistently, and you can probably imagine how much time that this took. So, now I'm not saying that grading rubrics would have been a one-size-fits-all solution. As we all know from teaching legal writing or from teaching transactional drafting, every individual assignment is going to have its own particular concerns that you want to focus on, but equally obviously, there's a lot of overlap between different assignments on larger picture issues, things you want to point out from assignment to assignment to beat into the students' heads. That's true in legal writing. It was true in my experience in legal writing. Others have advised that it's true in transactional drafting. I should have listened. Now, how do I fix this going forward? Well, the solution's easy. I've already started. I've started creating these rubrics that I should have been creating last semester or before the class started. And at least all the effort and the time that went into grading this past semester is going to pay off, because when I go back through and look at all I kept copies of all the student assignments, I can go back and pull out, this is exactly what I did in legal writing too, pull back all the recurring sorts of written assignments and written comments and transfer them into the grading rubrics that I'm going to use going forward. So that's the easy solution going forward from my perspective. An easier solution for those who are maybe teaching transactional drafting for the first time is to create those in advance, because it's going to be very difficult, at least in my experience, to try to create them in the midst of the semester. And there's perhaps at least a larger benefit from this and a couple of the other mistakes I'm going to talk about, mortifying though they might be to me, is that they remind me a little bit to be more sympathetic to my students who are learning something new for the first time, whether in legal writing or in transactional drafting, who are told over and over again how to do it right, who perhaps know how to do something objectively, and yet for whatever reason, they don't put it into practice at least the first time that they do it. So maybe it makes me a little bit more humble there, in dealing with legal writing students and transactional drafting students. It's easy for me to sit back and say, how many times have I told you to do this? Don't do this. And then, but I did the same thing when I was teaching transactional drafting for the first time. I knew what to do, and I didn't put it into play either. So maybe I should go a little bit easier on that. So that is the first of the rookie mistakes. The second rookie mistake from my perspective is one of TMI, too much information. Not for me, but for the students. Now, I might have been overconfident about my teaching experience, but I certainly was not about my substantive experience when transactional drafting. And when I look back now at this past semester, I realized that I was in the position of the student who does a lot of research on an office memo, who finds all kinds of materials and wants to find any way possible to work it all in, just to get credit for it. Look, I've done the research. See, I want to get credit for it. Regardless of whether the audience wants or needs that information. Now, what I'm alluding to is not really a matter of over-preparation per se. I suppose there could be some aspects of that. It's like, well, do I really want to prepare my class notes? Do I really want to grade this assignment? Do I really want to do this or this or this? Well, I can go read some more background materials. One, because, just out of intellectual curiosity anyways. This is really fascinating stuff. And second, I have to admit, if I'm being honest, that there maybe is a little bit of a measure of anxiety about not being caught short by a student's question during class, which in turn prompts me to, well, I'll just go read another article. I'll go read what various texts have to say about this particular issue to follow through on what my assigned text does. But ultimately, I'm not really sure that over-preparation, excess preparation, whatever you want to call it, is a problem per se. It's really just a matter of time management. And as long as you can fit preparation for class in with everything else you have to do, all your other obligations, both in school, family, or what have you, I'm not sure, I guess, that there really is such a thing as over-preparation from my perspective when it comes to teaching and preparing a new class. But the more important problem, and here's what the mistake is that it doesn't put all this stuff into my head, and the problem then for the students is I think it then led me want to do too much in class. In other words, sometimes having all this extraneous information floating around out there may have distracted me a little bit, or I allowed myself to be distracted. The blame is mine, not on the background materials. I allowed myself to be distracted from what really maybe the main focus of this drafting course is. Drafting, the actual skills that we're trying to teach our students about drafting. Not, of course, that transactional drafting is only about skills and not about substance. We all know that's not the case, or that the technical aspects of drafting can be divorced from substantive concerns. I'm not suggesting that at all. But what I found myself sometimes doing in class was wanting to skip past some of the basics, spending less time on that, so that I could move on to what to me were more interesting materials. And again, this is something I should have known better from my 10 years of legal writing, because over that decade, I've been paring down what I cover in that class. I try to, I'd rather cover fewer subjects at greater length than a more cursory survey. That's true both on the level of individual classes and the course as a whole. You just you can't cover everything. So I knew that objectively from my experience, and I'd seen it work. But I had a bit of a difficult time putting that into practice in teaching this new course for the first time. Now, going forward, how do I try to resolve this issue? Well, I've been reviewing my class notes, trying to go through and pare things out, what's essential, what's not essential, deciding what did and what didn't work. And that was something that at least I didn't have to wait to the end of the semester to do, over the summer. It started becoming apparent to me about halfway through the course that, that my class notes were way too detailed for the amount of time that I had. And so one thing I tried to do was all the background information that I used to be trying to wedge into the class in some way, somehow, I made a conscious effort to try to pull that information back out. I wouldn't assign that sort of background information before class. I might allude to it during class very briefly. I'd point students to it. I'd post it to my course website after class, so that interested students could delve a little bit deeper if they're so inclined. But I didn't want to, I stopped providing some of this background information before class as part of the reading because I didn't want students to get distracted from the essentials, what the text says, from the assignments they were supposed to be working on. I wanted them to focus on that a little bit more. So that's the second sort of rookie mistake. The third rookie mistake, it kind of arises out of this recurring sort of style versus substance dichotomy that we see in legal writing as well. And I'm not sure here, I had a hard time figuring out how to balance things on these lines, how much time to devote to these sorts of issues. And I think that I may have emphasized it a little bit too much, particularly early in the class. On the one hand, I'm an eager convert to the Tina Stark, to the Ken Adams approach to sort of drafting transactional documents in as straightforward a way as possible, trying to take even the most complicated documents and make them readable, eliminating legalese, doing anything we can to improve comprehension, and so on and so on. So when during class, when we'd have exercises up on the board, when I'd be done talking about the substantive issue that we might be talking about, a sample representation or covenant or what have you, I then might move on and say, and by the way, this isn't written all that well. As a matter of style, what can we do to sort of fix it? How can we change things? Now, and I started getting a little bit of pushback and questions from students about this. Some was pushback, I think, from a pragmatic, real-world perspective. Okay, this is, what's a senior attorney going to say when I make these sorts of changes? Or what's a client going to say? Or how am I going to find time to do that? Some were a little bit more theoretical, along the lines of, well, okay, but, in drafting, the focus is really on, does it convey the party's intent? Does it get the job done? And if that's the case, then does polishing it simply from a stylistic level, isn't that kind of just like a purely aesthetic exercise? It's nice if you have time, but who really has time? And I think that some of these questions that students were asking were coming because I think they were a little bit confused, perhaps, about the sorts of changes, what sorts of changes have substantive effect and which are more stylistic in nature. And their confusion was understandable because I didn't do a good job disentangling those different sorts of changes and trying to convey which are really the most significant and which aren't. Now, ultimately, and that's something, frankly, I'm just going to be working on, trying to work on and making, going forward. I mean, I know all the standard responses to why students should try to draft as clearly as possible, why they should make a conscious decision to clear up, what can often be, just lousy prose from form documents. I've tried to appeal to their self-interest, I've tried to appeal to the interest of their clients, and so on, but I'm just ultimately not sure how effective my responses were because I sometimes felt like I was climbing on a soapbox. Now, ultimately, I guess the ultimate result is that they did seem to get better on these issues. I mean, certainly as the course went on, the assignments improved along these on these lines. And it's not like I expected, the students to have some sort of communal hallelujah sort of moment. We get it now, stop telling us about it. But I think that this may, at the end, be one of those sorts of issues that, just like in legal writing, there are some things I just want to inculcate the students with, but you have to learn it from experience. They can learn it objectively, but they, again, have to go through it, actually experience it, to really understand the importance of it. Finally, in conclusion, I want to conclude here with a near miss. A mistake I almost made, but luckily didn't. And that mistake would have been not holding student conferences. Tina Stark recommends these in her teaching materials, but I wasn't sure where they'd fit into my schedule. I was teaching two other classes besides transactional drafting. I was looking at my schedule, trying to figure out logistically how it was going to work. And frankly, this I think ties into the fear, I wasn't necessarily sure what I would say in a conference anyways. So I did not put them on my initial syllabus. It wasn't until later, about 5 or 6 weeks into the class, and frankly, in part, as a reaction to the amount of time I was spending grading assignments. I was like, man, maybe I can short-circuit a little bit of this by talking with them individually. So I scheduled conferences to discuss my comments on the first major graded assignment. To my surprise, although these were optional, and although it's an upper-level course, and although I was kind of top-heavy with 3Ls in their final semester of law school, almost everybody signed up. And I thought the conferences went very well, not merely in terms of answering their questions and explaining my comments, but also it allowed me to pump them for their suggestions about improving the course, their thoughts about the class, and to help get to know the students as individuals. Now, of course, none of this was new to me, the value of holding conferences with students as a legal writing prof. But again, for some reason, I thought that it wouldn't work as well in an upper level course. I thought the upper level students might be a little bit more jaded. There might be more of a sort of forced dynamic. It wasn't. At least, admittedly, a small sample size, at least for this group of students. And in fact, these conferences worked so well that I scheduled another optional set of conferences during our last week of class, so coming right up against finals, to discuss the redraft of their last major assignment. And again, almost everyone signed up. So I mean, students want this, even upper-level students, they want this interaction, I think, with faculty that they don't get from lots of their other doctrinal profs and so on. And the conferences, more importantly, they seemed fruitful from my perspective. And again, small sample size alert, but students, at least a couple of them commented on the evals, that they found, again, that face-to-face time to be very valuable. And that, again, is something that you hear over and over again from students in legal writing, and I almost made the mistake of not transferring that over from legal writing to transactional drafting. So, in conclusion, so my focus today has been on mistakes, but please don't read me as accentuating the negative of teaching transactional drafting, because that is certainly not my intent. I love teaching this course. It's been very enjoyable, one semester down, and I'm looking forward to teaching it again this fall and going forward, and of course that will allow me to keep adding to this list of mistakes. So that brings us to the end of the formal panel. I'd like to remind you that there'll be a lunch roundtable tomorrow that continues this conversation about making the move from legal writing to transactional drafting. And I guess we have not only 10 minutes left, so I'd like to open the floor if there are any questions that you have for any of us on the panel.
Just a quick announcement before you guys start asking questions. At the end of this packet, there's an evaluation form for this program. Please fill them out. And I'll be here to collect them if you complete them before the program ends. If not, there's a box labeled evaluation forms in the lobby, right outside the rooms here where the coffee break was set up. Just throw them in there. Okay? Thank you.
So any questions? All right. Oh, yeah. Back.
I don't know how to phrase this very well. You see an overlap, like a lot of, as you know, teach legal writing as well. We spend a lot of time on organization, memos and briefs. You see overlap and that kind of concern about making clear organization, logical organization, as it applies to contract drafting.
The question is whether or not there's any overlap between the organizational focus, or one of the key focuses of legal writing, organization, and organization as a focus for contract drafting. Well, I mean, yeah, I'll give you my thoughts, and then certainly others on the panel can chime in. Certainly, I mean, and in fact, you know, one of the I think most of the drafting texts out there try to establish, you know, a sort of general organizational approach that makes sense, at least in the context of most deals. And that's one of the things that I tried to, you know, basing off the text that I was relying on, tried to instill in the students, and then, you know, so that at least they have a basic template or a basic approach that they can start with, and then recognizing that going forward there are going to be instances where they might need to deviate from that, just like they would in legal, you know, just like they often do with legal writing documents, or they might run into differently organized documents in the real world as well.
One thing I did with the two assignments that I've already mentioned several times is I had them turn in a separate document which where I asked them to list their business concerns and where they were addressing them in the proposed contract they were turning in. Were they addressing it as a covenant? Were they addressing it as a representation? Or were they addressing it not at all? And why? So that forced them to think about how they were going to organize it. Also taught them a little bit about what might be on the mind of a business, of a deal client, things that they, and working in groups, a lot of them brought experience into that others hadn't had. So it was a way of getting them to think about organization differently, and different than I do in legal writing.
I have my students do some exercises from a book that George Cuney co-wrote. I think it's Haggard's old book. There's a good list of organizational skills, importance, frequency. So if you've got a warranty issue for airplane seats, you know, sometimes they catch fire. That's really important, but it doesn't happen very often. How do you rate that? And so students can do really quick things for that. I want them to learn the general rule and then have enough practice where they know, when don't you do it that way? You know, and employment contracts work pretty well for that because they kind of are different than other types of contracts. And if you're an employee, what's the most important thing? My money. I want my money. And so maybe there's a different way to organize those things. And I did an assignment that's on the electronic exchange. I had my students rewrite the exclusionary agreement between Citicorp and Wachovia. It's a 2.5-page letter that was the source of a $60 billion lawsuit. And it's a terrible letter. It's just hideously bad. It's not even on letterhead because they forgot. And so the president of Citigroup had to scratch out where it says date in the agreement and handwrite in the margin what the end date of the exclusivity agreement was. And eventually, you know, it's really awful. Parts of it are quite good. And so I asked my students a list of questions at the end. They could choose a different format. They could keep it as a letter. So questions about the format, and also a question about the order. If you change the order, why? Because, as it turned out, you know, it needed to be in a different order.
No, go ahead, take another question.
This is a question for all of you, and I'm just kind of asking for your advice for what I think I've got a standard answer that I give my contract drafting students, but not a very good answer. And this goes, I've taught legal writing for years. I can be 100% confident in telling them, you will do in your firm what I'm teaching you to do here. You will write an objective memo, you'll write an appellate brief, whatever it is. The hardest questions I get then in the contract drafting side of it is, I'm an upper level third-year student. I've been working in a law firm, working for particular partners, working in different businesses. none of them draft contracts this way. I'm told not to spend time drafting this way. I'm told we don't have the time and resources to devote to best drafting practices. And I feel like I'm a little bit in la la land sometimes, wishing things would be this way. You have to wait for them to become senior members of firms before it starts making its way. Do you have an answer
I
when they
think
ask
that
this?
Brian Garner has a great answer to that question,
Okay.
and that's the answer that I give my students. When you control the draft, then consider X, Y, and Z. Oftentimes, when they're in the situation you're talking about, they don't control the draft.
Right.
They are very rarely going to control the draft early in their career. So, you know, they might control the draft when they draft a settlement agreement. A simple settlement agreement in a small case. I think that that is a pretty good answer. We're talking about best practices, best case scenario, not every day, all the time.
Okay, that's
Great answer.
good answer.
Anybody have a different answer?
I like your answer.
But I can't remember now because I'm going to steal that one.
If I could just say, well, I mean, again, because I do think, though, I can go back to the idea from the question is that there may be somewhere that, you know, again, they have to wait. I mean, it's like, you know, all we're just trying to do is flag these issues again when they control the draft, you know, or you know, when their job is no longer on the line necessarily quite so much if they make these changes, and you know, we're just trying to raise these issues and hope that maybe 5 or 6 or 7 years down the road, when they have a chance, they can make these sorts of adjustments going forward. I mean,
Can I have one quick response? If you talk about forms, hopefully your students will know enough to know when they have a good form, or maybe it's got illegalities in it. What should they do? You know, how do you evaluate a form? Because you can pick out the big problems. You may not fix the whole thing, but you can do some triage. There's a standard process to go through, and if they know the process, it'll work for any kind of deal.
Yeah, as we mentioned, you know, teaching them to work from a form is an essential skill in teaching contract drafting that is quite different from drafting from scratch.
Go ahead.
did you have a question?
Yeah, I have a question as to the popularity of your courses. Are they typically oversubscribed?
My course fills in about 6 seconds, and it's got room for 20, because I know one of my TAs tried to take it, and it was the first course he entered. He thought it took about 8 seconds, and he's on the wait list.
So your course is limited in size to 20, and it fills very quickly. Carolyn?
My class has a deeper, I'm the director of legal writing at my law school, so I monitor the waiting lists on all the classes, and I'm constantly trying to persuade my associate dean to let me offer more classes. And the transactional drafting class, the deal drafting class, has a longer wait list than any other course. Advanced brief writing, legal writing and litigation, a general drafting course where we talk about general drafting principles. So, but we only offer one section of it. So, you know, our ABW classes, we offer 5 sections. So it's not surprising that the wait lists are shorter.
So I had a limit of 20 students in one section, and I had a huge wait list. And so now I'm teaching 2 sections of contract drafting this fall.
We've gone to 4 or 5 sections a year just in the last 3 years. And they're all full, and they're all oversubscribed. And people wait till their 3rd year to take it. They go see the executive assistant dean with the longest title if they don't get in. My firm said I had to take this. So hopefully that will help, because it's hard. I mean, it's hard to justify the resources for 16 or 18 or 20 students, except that they all want it.
Except that they all want it.
We've actually changed our curriculum at Wake we have the first year legal research and writing goes all year 1 and 2. And it used to be that for a 3rd semester you had to take appellate advocacy. Our students can now take a 3rd semester of either appellate advocacy or contract drafting or litigation drafting. And they can take it any time in their 2nd or 3rd year. So,
and some students try to take all 3.
And some do, yeah. They can take more than one, but they only have to take one.
Because we're done.
Is there any other questions?
There are cocktails somewhere?